Hey, 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 everybody. Peace and love. Peace and love. It is your girl, Shay Marie, back for another video. It has been quite some time since I've done a video, since I've came on and did any type of reading. So I noticed that I was getting a lot of viewers and people taking interest into the Straw Man book that I read last year. And that book actually has a couple of other books that comes with it as well. So what I wanted to do is come on today and update you all on some things that has been taking place. Let you know about the Telegram channel that I have started back up, to the people, to start getting people, to start helping people with certain things, to start teaching you the things that I know, and we can also still learn together, because I am not closed-minded person at all. But these are two books that comes or that goes along with from the same authors, that goes with the Meet Your Straw Man book. So today what I wanted to do is come on and read the UCC Connection, How to Free Yourself from Legal Tyranny. Okay. I'm going to get through as much of this book as I possibly can. It's not long, just like the other one wasn't long at all. So we're going to go through this book. Like I said, I in the description of the video, I've already put some information on how you can join the Telegram chat that I've created to open up to the public. Now, I want to say some things. If you're looking to just come in and join and just be a sitting log in there and not communicate, not interact as a community, and you're just coming there just to see what's being put in the group to take away, then that's not what I'm looking for. That's not what I want. So, you know, if you join my Telegram chat and you're not interactive within the first maybe week of you joining, I'm booting you out. I am going to be doing classes next Wednesday. I'm going to be going live to do a meet and greet and Q&A to kind of see where everyone's heads are at, from those that have listened to the Meet Your Straw Man and have been doing their own other research to dive deeper into this information that is being presented to you, because I want to let you guys know there's a lot of amazing things that are taking place, that you guys need to definitely be preparing yourself for, if that is something that you're interested in doing, to free yourself, to free your family, and you're serious about it. Because I'm only looking for serious people. I'm not looking for anyone that I have to hold their hand every step of the way. You're not putting forth no real good effort to help free yourself. I'm only looking for those that are, wanting to do the work to free themselves. I'm not really charging anyone for my time, other than if you want free consultations, or if you want, not free consultations, but if you want personal consultations with me, and you want to sit on the phone or sit on a Zoom for a few hours going over personal things, then that's when it's going to come into a monetary donation that I am going to be requiring. However, as we learn together in the Telegram, I'm going to be scheduling weekly classes that you will have to show up to and participate and show that you're doing your homework and whatnot. I'm not playing. This is serious business, because things are definitely getting ready to take place, and you definitely want to start positioning yourselves like seriously positioning yourselves to begin reaping some of the harvest that is definitely going to be available to us. It's already available to us, not say be going to be, but it's already very well available to you. So you want to definitely start setting yourselves up. So with that being said, I'm definitely opening myself to help as many people as I possibly can. As I stated in the comments of the Straw Man book, I'm opening up my Telegram channel to the first 100 people. So to the first 100 serious people, you have to be working, because we need to be serious about this and coming together and creating our own individual communities within, wherever we are, and helping to branch out and teach our own families, teach our own children, and teach those around us of the greatness of the information that we have available to us to free ourselves from what's happening. I know you all see, the prices rising in the stores, there's food shortages, and there's no reason whatsoever. There are people, there are things in place to help everyone. But a few things got to happen. People have to humble themselves, number one. There has to be a lot of healing that needs to take place, and a lot of truths need to be exposed, and a lot of truths need to just be accepted. And people need to stop fighting against one another. We need to stop fighting against one another and come together. And so, I said this last year when I came out to the public on, um, Brother B Miles channel, if that's where you learned of me from. When I made my presentation to a large community of people, to try to bring us together, to try to show you all how we could come together and create and develop a community, build wealth together, and branch out and do it in our own subdivisions or whatever. We all don't have to always stick together, and we don't always have to get along, but we definitely have to be respectful of one another and things of that nature. So it's been a minute since I've done a live, so I know I'm ranting and I'm supposed to be reading, but I just wanted to let you all know the excitement that is definitely taking place. Things are definitely things are definitely starting to get more exciting. There's a whole community of people that are, figuring this thing out, you guys, and coming together, working together to figure this thing out, to find remedies for people, helping people that are in dire situations, getting kicked out of homes and utilities getting shut off. We figuring this stuff out, y'all. These people thought they had us and that we wasn't gonna figure this shit out. Excuse my language. I gotta speak like this. I'm just being myself. But it's coming to fruition. It's coming to a pass, and we're not going to be needing and wanting for anything ever again. We're definitely reclaiming our throne, reclaiming everything that these devils have stolen from us as the heirs of this whole planet. You know, it's definitely coming back to us. So I hope you guys are excited. I hope you guys are paying attention and taking it serious, and not thinking that people that are out here sharing this information with you are crazy, because we're not crazy. We might be crazy because this shit is not easy. It's been a long road. I've been studying for the past 3 years faithfully, and it's just now coming to the light by the grace of the great universe and the great mother, and the great spirit that is wanting to see her people, free and live in abundance, that this thing is coming to pass. And it's a great time to be alive. It's definitely a great time to be alive. So what I'm gonna go ahead and do is start reading. Let me see if I have any comments. If you want to comment in the chat, you definitely can. I am able to see the chat. And I'm going to go ahead and start reading the book. So it's the UCC Connection, How to Free Yourself from Legal Tyranny. Happy is the man that findeth wisdom, and the man that getteth understanding. Proverbs 3 and 13. We the people. Governments are instituted among men deriving their just powers from the consent of the governed. Okay. This article has filled in the voids that kept me from fully understanding things. I found it to be one of the best discussions on the subject of freedom and how our own government has managed to take that freedom away. That's a great book. Had about a month now. Still learning. Yeah, I've actually had these books for a while. I only read The Straw Man, so I decided to read this one because we actually dived into a few other books over the past year. So now I'm going to come back to this one because, through our research and development, everything is basically circling back around. So I thought this would be a great time to come and add this book to my channel as as a great book to promote, to help people get more understanding of what is actually taking place with this system and how you can free yourself. And like I said, we're learning together in the Telegram chat as well. If you're interested in more information, there's a lot of remedies and things that we're discovering that are working, and lives are definitely being changed. So I wanted to open that up to more people and be able to help more people. I had to close it down for a while because, um, it was just no one was really, really taking action. And so it was just as if people were just being vultures. And that's not what I'm looking to do. I'm looking to work with serious people that want to put in the work and not just sit around waiting for everybody else to do it, which I've already done pretty much, but I just didn't like the fact that there was only a handful out of over hundreds of people sitting there not doing anything or not showing up to anything that I was providing for absolutely free on a consistency to the people. So, now I'm opening back up and giving people another opportunity to take advantage of what's happening to help free yourself, because we don't have to be in this situation, that in the situations that we're in. We just have to educate ourselves and discipline ourselves to go after what is ours, because it's not going to be handed to us. So those that are waiting for stuff like Nasara Jasara to pop off or whatever, keep waiting, because it's not going to just be given to you. The information is out here for you to get for yourself and go after what belongs to you. So with that being said, I'll continue this reading. The title of this article, The UCC Connection, the noteworthy author is Howard Friedman. It is dated September 22nd, 1991. That's my son's birthday. The UCC Connection, How to Free Yourself from Legal Tyranny by Howard Friedman. Forward. This is a slightly condensed, casually paraphrased transcript of tapes of a seminar given by Howard Friedman in 1990. It was prepared to make available Mr. Freeman's knowledge and experience in his search for an accessible and understandable explanation of the confusing state of the government and the courts. It should be helpful to those who want to develop a deeper understanding of this information without having to listen to 3 or 4 hours of recorded material. The frustrations many Americans feel about our judicial system can be overwhelming and often frightening, and like most fear, it is based on the lack of understanding or knowledge. Those of us who have chosen a path out of bondage and into liberty are faced eventually with the seemingly tyranny power of some governmental agency and the mystifying and awesome power of the courts. We have been taught that we must get a good lawyer, but that is becoming increasingly difficult, if not impossible. We are defending ourselves from the government. If we are defending ourselves from the government, we find that the lawyers quickly take our money and then tell us as the ship is sinking, I can't help you with that. I'm an officer of the court. Ultimately, the only way for us to ever have a snowball chance is to understand the rules of engagement and to come to the understanding of the true nature of the law. The lawyers have established a secured and virtual monopoly over this area of human knowledge by implying that the subject is too difficult for the average person to understand, and by creating a separate vocabulary out of English words of otherwise common usage. While it may at times seem hopelessly complicated, it is not that difficult to grasp. Are lawyers really as smart as they would have us believe? Besides, anyone who has been through a legal battle against the government with the aid of a lawyer has come to realize that lawyers know procedure, not law. Then answered one of the lawyers and said unto him, Master, thus saying thou reproachest us also. He said, We woe unto you also, ye lawyers, for ye laid men and burdens grievous to be borne, and ye yourselves touch not the burdens with one of your fingers. Woe unto you, lawyers, for ye have taken away the key of knowledge. Ye entered not in yourselves, and them that were entered in ye hindered. Christ teaches his disciples at Luke 11:45 through 52. So we are learning that the Bible has plays a lot into law, and exposing the truth of what is really taking place, and that church kind of kept us deceived about that fact and truth. Okay. So it says, besides, anyone who has been through a legal battle against the government with the aid of a lawyer has come to realize that lawyers learn about procedure, not about law. Mr. Freeman admits that he is not a lawyer, and as such he has a way of explaining law to us that puts it well within our reach. Consider also that the framers of the Constitution wrote in language simple enough that the people would understand specifically so that it would not have to be interpreted. So again, we find, as in many other areas in life, the buck stops here. It is we who must take the responsibility for finding and putting the good use the truth, putting to good use the truth. It is we who must claim and defend our God given rights and our freedom from those who would take them from us. It is we who must protect ourselves, our families, and our posterity from the inevitable intrusion into our lives by those who live parasitically off the labor, skill, and talents of others. To these ends, Mr. Freeman offers a simple, hopeful explanation of our plight and a peaceful method of dealing with it. Please take note that this lecture represents one chapter in the book of understanding, which he is always refining, expanding, and improving. So that's why I made in the comments, because that book that I read, The Straw Man, I read that a year ago, and as we can see, this information is from the 1990s, and a lot of things have changed. So when certain things, certain procedures and things of that nature are given in these books, it can be helpful, but you want to still do more research and figure out more in an updated way, because they've changed things as we started figuring out these things. Okay, So this is why I created the Telegram chat, because I know people are probably trying to do things from the straw man book that I read, and it may be a little bit outdated, and there may be some updated things that you can do to help yourself. Okay, so you want to join the Telegram chat. Keep to keep on. It says, "I send you forth as a sheep in the midst of wolves. Be ye therefore wise as serpents and harmless as doves." Matthew 10:16. Introduction. When I beat the IRS, I used Supreme Court decisions. If I had tried to use these in court, I would have been convicted. I was involved with a patriot group and studied Supreme Court cases. I concluded that the SC had declared that I was not a person required to file an income tax, that the tax was an excise tax on privileges granted by government. So I quit filing and paying income taxes, and it was not long before they come down on me with a heavy hand. They issued a notice of deficiency, which had a which had such a fantastic sum on it that the biggest temptation was to go in with their letter and say, "Where in the world did you ever get that figure?" They claimed I owed them $60,000. But even if I had been paying taxes, I never in the world had that much money. So how could I have owed that much? Section 1. Never argue the amount of deficiency. Fortunately, I had been given just a little bit of information. Never argue the facts in a tax case. Maxim arguments are for fools. If you're not required to file, what do you care whether they say you owe $60 or $60,000? If you are required to file, the amount doesn't matter. Don't argue the amount. That is an issue of fact. In most instances, when you get a notice of deficiency, it is usually for some fantastic amount. The minute you say, "I don't owe that much," you have voluntarily agreed that you owe them something, and you have just given them jurisdiction. Just don't be shocked at the amount of the notice of deficiency, even if it's $10 million. If the law says that you are not required to file or pay tax, the amount doesn't matter. By arguing the amount, they will just say that you must go to tax court and decide what the amount is to be. By the time you get to tax court, the law issues are all decided. You are only there to decide how much you owe. They will not listen to arguments of law. So I went to see the agent and told him I wasn't required to file. He said, "You are required to file, Mr. Freeman." But I had all these Supreme Court cases and started reading them to him. He said, "I don't know anything about law, Mr. Freeman, but the code says that you are required to file and you're going to pay that amount or you're going to go to tax court." I thought that someone there ought to know something about law, so I asked to talk to his superior. I went to him and got out my Supreme Court cases, and he wouldn't listen to them. "I don't know anything about law, Mr. Freeman." Finally, I got to the problems resolution officer, and he said the same thing. He said that the only person above him was the district director. So I went to see him. By the time I got to his office, they had phoned ahead and his secretary said he was out, but I heard someone in his office and I knew he was there. I went down the elevator around the corner to the federal building and into Senator Simpson's office. There was a girl sitting there at a desk and she asked me if she could help me. I told her my problem. I said I really think the district director is up there. I asked her to call the IRS and tell them that it was Senator Simpson's office calling and to ask if the district director is in. I said, "If you get him on the phone, tell him that you are from the senator's office and you have a person whom you are sending over to speak to him. If he is Can he wait just 5 minutes? It worked. He was there, so I ran back up to his office. His secretary met me when I came in and said, Mr. Freeman, you're so lucky. The director just arrived. Right. The director was very nice and offered me a coffee and cookies. We sat and talked, so he asked me what I wanted to talk to him about. If you've never have someone to say, I'm from the government and I'm here to help you, watch out. But we can turn that around and approach them in the same way. So I said, I thought you ought to know that there are agents working for you who are writing letters over your name that you wouldn't agree with. Do you read all the mail that goes out of this office over your signature? The director said, Oh, I couldn't read everything. It goes out here by the bagful. That was what I thought, I said. There are some of your agents writing letters which contradict decisions of Supreme Court of the United States, and they're doing it over their name, and they're doing it over your name. He was very interested to hear about it and asked if I had any examples. I just happened to have some with me, so I got them out and represented them or presented them to him. Supreme Court cases, Freeman's position. Supreme Court cases supporting Freeman's position. The director thought it was very interesting and asked if I could leave this information with him, which I did. He said he would look it over and contact me within 3 days. 3 days later, he called me up and said, I'm sure, Mr. Freeman, that you will be glad to know that your notice of deficiency has been withdrawn. We've determined that you're not a person required to file. Your file is closed and you will hear no more from us. I haven't heard another word from them since. That was in 1980. I haven't filed since 1969. Wow. Section 2. The Supreme Court on trial. I thought sure I had to answer, but when a friend got charged with willful failure to file in income tax, he asked me to help him. I told him that they would have to prove that he willfully failed to file, and I suggested that he should put me on the witness stand. He should ask me if I spoke at a certain time and place in Scotts Bluff, and did I see him in the audience. He should then ask me what I spoke about that day. When I got on the stand, I brought out all the Supreme Court cases I had used with the with the district director. I thought I would be lucky to get a sentence or two out before the judge cut me off, but I was reading whole paragraphs and the judge didn't stop me. I read one and then the other, and so on. And finally, when I had read just about as much as I thought I should, the judge called a recess of the court. I told Bob I thought we had it made. There was just no way that they could rule against him after all that testimony. So we relaxed. The prosecution presented its case, and he, Bob, decided to rest his case on my testimony, which showed that he was not required to file and that the Supreme Court case had upheld this position. The prosecutor then presented his closing statements, and we were just sure that he had won. But at the very end, the judge spoke to the jury and told them, "You will decide the facts of this case, and I will give you the law." The law required this man to file an income tax form. You decide whether or not he filed it. What a shock. The jury convicted him. Later, some of the members of the jury said, What could we do? The man had admitted that he had not filed the form, so we had to convict him. As soon as the trial was over, I went around the judge's office and he was just coming in through his back door. I said, Judge, by what authority do you overturn the standing decisions of the United States Supreme Court? You sat on the bench while I read that case law. Now, how do you, a district court judge, have the authority to overturn decisions of the Supreme Court. He says, "Oh, those were old decisions." I said, "Those are standing decisions. They have never been overturned. I don't care how old they are. You have no right to overturn a standing decision of the U.S. Supreme Court in a district court." Section 3, Public Law versus Public Policy. He said, "My name, decision of the Supreme Court." He said, "Name any decision of the Supreme Court after 1938 and I'll honor it. But all the decisions you read were prior to 1938." He went on, "Prior to 1938, the Supreme Court was dealing with public law. Since 1938, the Supreme Court has dealt with public policy. The charge that Mr. S was being tried for is a public policy statute, not a public law, not a public law, and those Supreme Court cases do not apply to public policy." I asked him what happened in 1938. He said that he already told me too much. He wasn't going to tell me anymore. Section 4. Let's check this. Let me check the truths, also called courts or tax courts, right? What's your Telegram name? So the Telegram chat is in the link to the Telegram chat is in the description area of the video. So you guys can get to that through there, to the Telegram chat. Thank you so much. I'm ready and willing. Okay, you're welcome. Grand Rising, the Empress, the Straw Man book is the truth. Absolutely. Mrs. Somebody or Mr. Somebody. So I'm going to take a drink of water, guys. Give me a moment, please. All right. Let me know how I'm doing with the reading, if I'm boring you all. Okay. So, Section 4, 1938, and the Erie Railroad. Well, I began to investigate. I found that 1938 was the year of the Erie Railroad versus Tompkins case of the Supreme Court. It was also the year the courts claimed they blended law with equity. I read the Erie Railroad case. A man had sued the Erie Railroad for damages when he was struck by a board sticking out of a boxcar as he walked along beside the track. The district court had decided on commercial law, negotiable instrument law, that this man was not under any contract with the Erie Railroad and therefore he lacked standing to sue the company. Under common law, natural law, he was damaged and he would have had the right to sue. This overturned the standing decision of over 100 years. Swift versus Tyson in 1840 was a similar case, and the decision of the Supreme Court then was that in a case of this type, the court would judge by the common law, natural law, of the state where the incident occurred, in this case, Pennsylvania. In the Erie Railroad case, the Supreme Court now ruled that all federal cases will be judged under the negotiable instruments law. There would be no more decisions based on common law at the federal level. So here we find the blending of law with equity. This was a puzzle to me. As I put these new puzzles together, I reasoned that all courts since 1938 were merchant law courts and not common law courts. There were still pieces missing from the puzzle. Section 5, a friend in court. Fortunately, I made a friend of a judge. Now, you won't make friends with a judge if you go into the court like a wolf in black sheep country. You must approach him as though you are the sheep and he is the wolf. If you go into court as a wolf, if you make demands and tell the judge what the law is, he how he had better uphold the law or else. Remember the verse, I send you forth as sheep in the midst of wolves, but ye therefore wise. I'm sorry, it says, be ye therefore wise as serpents and harmless as doves. We have to go into court and be wise and harmless and not make demands. We must be humble and play a little dumb and ask a lot of questions. Well, I asked a lot of questions and boxed the judges into the corner where they had to give me a victory or admit what they didn't want to admit. I won the next case, and on the way out, I had to stop by the clerk's office to get some papers. One of the judges stopped and said, you're an interesting man, Mr. Freeman. If you're ever in town, stop by, and if I'm not sitting on a case, we will visit. Section 6. America is bankrupt. Later, when I went to visit the judge, I told him of my problem with the Supreme Court cases dealing with public policy rather than public law. He said in 1938, all the higher judges, the top attorneys, and the U.S. attorneys were called into a secret meeting, and this is what we were told. America is a bankrupt nation. It is owned completely by its creditors. The creditors own Congress, they own the executive, they own the judiciary, and they own all the state governments. Take silent judicial notice of this fact, but never reveal it openly. Hmm, that's very interesting, guys. Your court is operating under Admiralty jurisdiction. Call it anything you want, but do not call it Admiralty. Section 7, Admiralty Courts. The reason they cannot call it Admiralty jurisdiction is that your defense would be quite different in Admiralty jurisdiction from your defense under the common law. In Admiralty, no court has jurisdiction unless there is a valid international contract in dispute. When you know it is Admiralty jurisdiction and they have admitted on the record that you are in Admiralty court, you can demand that the international maritime contract to which you are supposedly party and which you supposedly have breached be placed into evidence. No court has Admiralty maritime jurisdiction unless there is a valid international maritime contract that has been breached. So you say, just innocently like a lamb, well, I never knew that I got involved with an international maritime contract, so I deny that such a contract exists. If this court is taking jurisdiction in Admiralty, then place the court into evidence so that I might challenge the validity of the contract. What they would have to do is place the national debt into evidence. They would have to admit that the international bankers own the whole nation and that we are the bankers' slaves. Section 8. Not expedient. But the bankers said it is not expedient at this time to admit that they own everything and could foreclose on every nation of the world. This is the key behind the buildup of the nations as a military force. This is the key to disarming America. This is the key to ending the ending the Cold War. Like now, we have no more enemy, so we can melt all our guns. Wrong. The bankers plan to foreclose, they just don't want their heads blown off while doing it. So they dictate to Congress to get rid of the guns, etc. The reason they don't want to tell everyone that they own everything is that there are still no many there are still too many privately owned guns in America today. Our other military forces, there are I'm sorry, there are uncooperative armies and other military forces. So until they can gradually consolidate all armies into a world army and all courts into a world court, it 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 is not expedient to omit the jurisdiction of the courts they are operating under. When we understand these things, we realize that there are certain secrets they don't want to admit, and we can use this to our benefit. Jurisdiction. The Constitution of the United States mentions three areas of the jurisdiction in which the courts may operate. Section 10, Common Law. Common law, natural or constitutional law, is based on our Creator's laws as originally presented by Moses. Anytime someone is charged under the common law, there must be a damaged party. You are free under the common law to do anything you please, as long as you don't infringe on the lives, liberty, or properties of someone else. You have a right to make a fool of yourself provided you do not infringe on the life, liberty, or property of someone else. The common law does not allow for any government action which prevents a man from making a fool of himself. For instance, when you the cross when you the cross state lines when you cross state lines, you will probably see a sign which says buckle your seatbelts. It's the law. This cannot be common law because who would you injure if you did not buckle up? Nobody. Exactly. This would be compelled performance. The common law cannot compel performance. Any violation of common law is a criminal act that is punishable. Section 11, equity law. So let me stop right there. Basically, it's saying that the only real law, you guys, is the law that says if you hurt someone else or if you infringe upon someone else's property, like, robbing them and things like that, those are the only two laws that you can be tried for. Those are the only two things that are considered a crime. So everything else is basically their statutes and codes that they are enforcing up on us. Um, and it's not natural law. It's not common law. So it's basically just statutes and codes, and it really doesn't apply to us. But we allow it to apply to us by acquiescing to it because we are of our ignorance of real law. So Section 11, equity. Equity law is law which compels performance. It compels you to perform to the exact letter of any contract that you are under. So if you have compelled performance, there must be a contract somewhere and you are being compelled to perform under the obligation of the contract. Now, this only can be a civil action, not criminal. In equity jurisdiction, you cannot be tried criminally, but you can be compelled to perform to the letter of the contract. If you then refuse to perform as directed by the court, you can be charged with contempt of court. This is a criminal action. Are 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 our seatbelts? I'm sorry. Are our seatbelts laws, equity laws? No, they are not, because you cannot be penalized or punished under equity jurisdiction for not keeping to the letter of a contract. This, of course, changed since the publishing of this article, so read on. Section 12, Admiralty or Maritime Law. Admiralty is a civil jurisdiction of compelled performance, which has criminal penalties for not adhering to the letter of a contract, but this only applies to international contracts. Now we can see what jurisdiction the seatbelt the seatbelt laws and all traffic laws, building codes, ordinances, tax codes, etc. are under whenever there is a penalty of failure to perform, such as willful failure to file. That is Admiralty maritime law, and there must be a valid international contract in force. However, the courts don't want to admit that they are operating under Admiralty maritime jurisdiction, hereafter noted as AM. So they took the international law or law merchant and adopted it into our codes. This is what the Supreme Court decided in the Erie Railroad case, that the decisions would be based on commercial law or business law, and that there will be criminal penalties associated with it. Since judges were instructed to call it AM jurisdiction, they call it statutory jurisdiction. I looked for statutory jurisdiction in the fourth edition of Black's Law Dictionary. It's not there. So I looked up statute, and under its definition in this paragraph, this word is used to designate the written law in contradistinction to the unwritten law. Forster versus Brown, 199. GA 444, 34 Section E 2D 530, 535, C common law. Unwritten law is common law. So common law basically is just common sense, y'all. Like what's common sense? But as we can see, common sense is not so common because we've been brainwashed. So Section 13, Courts of Contract. You may ask how we got into this situation where we can be charged with failure to wear seatbelts and be fined for it. Isn't the judge sworn to uphold the Constitution? Yes, but you must understand that in Article 1, Section 10, the Constitution gives us the unlimited right to contract as long as we do not infringe on the life, liberty, or property of someone else. Contracts are enforceable, and the Constitution gives two jurisdictions where contracts can be enforced: equity or admiralty. But we find them being forced in statutory jurisdiction. This is an embarrassing part of the courts that we can use to box the judges into a corner in their own courts. We will cover this more later. Section 14. Contracts must be voluntary. Under the common law, both parties must enter into every contract knowingly, voluntarily, and intentionally, or the contract is unenforceable and void. These are characteristics of a common law contract. There is another characteristic. The contract must be based on substance. For example, contracts used to read for $1 and other valuable consideration. I will paint your house, etc. That was a valid contract. The dollar was a genuine silver dollar. Now, suppose you wrote a contract that said for one Federal Reserve note or other consideration, I will paint your house. And suppose, for example, I painted your house the wrong color. Could you go into a common law court and get justice? No, you could not. No substance, no contract. You see, a Federal Reserve note is a colorable dollar as it has no substance. And in a common law jurisdiction, that contract would be unenforceable. Colorable, that which is in appearance only and not what it purports to be. Hence counterfeit, feigned, having the appearance of truth. Black's Law Dictionary, 5th edition. Section 15. Colorable money and colorable courts. The word colorable means something that appears to be genuine but is not. Maybe it looks like a dollar and maybe it spins like a dollar, but if it is not redeemable for lawful money, silver or gold, so only silver and gold is lawful money. By now, you guys should know that. It is colorable, fiat, fake, false. It is, if a Federal Reserve note is used in a contract, then the court contract becomes a colorable contract. A colorable contract can only be enforced under a colorable jurisdiction. So by creating Federal Reserve notes, the government had to create a colorable jurisdiction to cover the kinds of contracts that use them. We now have what is called statutory jurisdiction, which is not a genuine admiralty jurisdiction. Judges are enforcing a colorable admiralty jurisdiction because we are using colorable money. Colorable admiralty is now known as statutory jurisdiction. So let's see how we got under this jurisdiction. Section 16, Uniform Commercial Code. The government established a colorable law system to fit the colorable currency. It used to be called the law merchant or the law of redeemable instruments because it dealt with paper which was redeemable in something of substance. But once Federal Reserve notes had been declared unredeemable, there had to be there had to be a system. I'm sorry. There had to be a system of law which was completely colorable from start to finish. This system of law is codified as the Uniform Commercial Code, UCC, and has been adopted in every state of the Union. This is colorable law, used in all of the courts of the nation. I explained one of the keys earlier, which is which is that the country is bankrupt and we have no rights. If the master says jump, the slave had better jump because the master has the right to cut off his head. As slaves, we have no rights, but the creditors, the masters, had to cover up the fact so that so they created the system of law called the UCC. This colorable jurisdiction under the UCC is the next key to understanding what has happened. Section 17, Contract or Agreement. One difference between common law and the UCC is that in common law, contracts must be entered into 1. Knowingly, 2. Voluntarily, and 3. Intentionally. Under the UCC, this is not so. First of all, contracts are not necessary, but under the UCC, agreements can be binding. And if you only exercise the benefits of an agreement, it is presumed or implied that you intend to meet the obligations associated with those benefits. If you accept a benefit offered by government, you are obligated to follow every statute involved with that benefit. So their method is to get everybody exercising a benefit, and they don't even have to tell the people what the benefit is. Some people think it's a driver's license, the marriage license, or the birth certificate, etc. I believe it's none of these. Section 18, the compelled benefit. I believe the benefit being used is that we have been given the privilege of discharged debt with limited liability instead of paying debt with substance. When we pay a debt, we give substance for substance, equal value for equal value. If I buy a quart of milk with a silver dollar, that dollar paid for the milk, and the milk paid for the dollar. Substance for substance, pound for pound. But if I use a Federal Reserve note to buy the milk, I have not paid for it. And this is what everybody doesn't know. A lot of people don't know this. And if you don't know it, you don't understand it. But so if we're going in the store and we're paying for things with Federal Reserve notes, basically the dollar bills, whatever, $20, $1, $100 bill, don't matter. We're still not paying for it. And so by it still not being paid for, you guys, whether you think you own it or not, you don't. It's not yours. It's in your possession, but you don't own it technically. Reason why is because you were given a receipt. and you were given a receipt, because when you gave the Federal Reserve note, you were just basically making a deposit. So this stuff is deep. As we dive into this stuff, you guys, it's kind of fun learning, but it's very deep, and you got to keep studying at it to get an understanding to say, oh, that's what they're doing. But yeah, so even when we get receipts, when we pay for stuff, we're getting a receipt. That receipt still has a meaning. So what I want to say to that is, start holding on to your receipts. Do not throw those receipts away, because those receipts are worth money. Okay? So that's just a little tip there for you. Some free sauce, what they say. Okay? Receipts equals money. So don't throw them away, because there's something that you can do with those receipts, you guys, to get every dime that you spent back. Okay? With that being said, let's move forward. Congress offers us the remedy in the form of a benefit. Debt money, fake money, authorized by the federal United States, can be spent all over the continental United States, and it is declared legal tender for all debts, public and private. So it's legal tender, it's not money. And the limited liability is that you cannot be sued for not paying your debts when you discharge the debt using the colorable money. Okay? So they have said, we're going to help you out. You can discharge your debts instead of paying your debts. When we use the colorable money to discharge our debts, we cannot use common law courts. We can only use colorable law courts. We are under the jurisdiction of the UCC. We are using non-redeemable negotiable instruments, and we are discharging debt rather than paying debts. So know that when you think you're paying a debt, you're not really paying a debt. And so you're out here punching the clock for debt notes to pay a debt that you think you're paying, and you're not. So you're just being deceived all the way around, you guys. Okay? And I want you all to wake up to this fact, and start helping to wake your other people up too, so that they can become knowledgeable of this fact. Okay? So that we can join together in unity and come against these people the way that we need to. Section 19, remedy and recourse. Every system of civilized law must have two characteristics: remedy and recourse. Remedy is a way to get out from under the law. Recourse is if you have been damaged under the law, you can recover your loss. The common law, the law of merchants, and even the UCC all have remedy and recourse, but for a long time we could not find it. If you go to the law library and ask to see the UCC, they will show you a shelf of books completely filled with the UCC. When you pick up one volume and start to read, it will seem to have been intentionally written to be confusing. It took us a long time to discover where the remedy and recourse are found in the UCC, and they are found right in the first volume, the UCC 1207 and 1-103. Section 20, remedy. The making of a valid reservation of rights preserves whatever rights the person possessed at the time, and prevents the loss of such rights by application of the concepts of waiver or estoppel. UCC 1-207.7. It is important to remember when we go into a court that we are in a commercial international jurisdiction. If we go into court and say, I demand my constitutional rights, the judge will most likely say, you mention the Constitution again and I'll find you in contempt of court. We don't then understand how you cannot do that. Hasn't he sworn to uphold the Constitution? The rule here is this: you cannot be charged under the jurisdiction and defend under another. For example, in the French government, if the French government came to you and asked you where you filed your French income tax for a certain year, do you go to the French government and say, I demand my constitutional rights? No. The proper answer is, the law doesn't apply to me. I'm not a Frenchman. You must make your reservations of rights under the jurisdiction in which you are charged, not under some other jurisdiction. So, in a UCC court, you must claim your reservation of rights under the UCC 1-207, now changed to UCC 1-308. So, this can be done by, so if for instance, you can tell, like if you have interaction with the court, you can say, UCC 1-308, all rights reserved, without prejudice, without recourse. They're supposed to leave you alone. You can also, when you're signing your documents, put that near your signature, above or below your signature. UCC 1-308, all rights reserved, without recourse, without prejudice. So if you guys go to the Telegram chat, you're going to learn that. And I'll also be teaching you how to sign your name properly and things of that nature as well, because what we don't know is that we're beneficiaries of a trust. We're all trust babies. So if you've been listening to the videos that are on my channel, you should by now know that you are a beneficiary of a trust, because I've been putting up a lot of information about the Sestate trust and that you are the beneficiary and how to express this trust and things of that nature. So if you've been following the channel, these things you should know by now. Okay. Continuing on to section 21, it says UCC 1-308 goes on to say, when a waivable right or claim is involved, the failure to make a reservation thereof causes the loss of the right and bars its assertion as at a later date. UCC 1-308.9. You have to make your claim known early. Further, it says, the sufficiency of the reservation. Any expression indicating an intention to reserve rights is sufficient, such as without prejudice. UCC 1-308.4. So that's why you say without prejudice, okay, guys? Whenever you sign any legal paper that deals with Federal Reserve notes in any way, whatever you sign, whether it's a job application, whether it's a application for whatever, a credit card, whatever you're putting your signature on, always put UCC 1-308, all rights reserved without prejudice, without recourse, okay? This reserves your rights. You can see at 1-308 that you have sufficiently reserved your rights. It is very important to understand just what this means. For example, one man who used this in regards to a traffic ticket was asked by the judge what he meant by writing without prejudice on his statement to the court. He had not tried to understand the concepts involved. He only wanted to use it to get out of paying for the ticket. He did not know what it meant. When the judge asked him what he meant by signing in that way, he told the judge he was not prejudiced against anyone. The judge knew that the man had no idea of what it meant, so he lost the case. You must know what it means. So you got to educate yourself, guys. Section 22, without prejudice, UCC 1-308. When you use without prejudice or without prejudice, UCC 1-308, in connection with your signature, you are saying, I reserve my right not to be compelled to perform under any contract or commercial agreement that I did not enter into knowingly, voluntarily, or intentionally. I do not accept the liability of any compelled benefit or any unrevealed contract or commercial agreement. So I'm going to get my highlighter for y'all. And I'm going to highlight this. And I'm going to hold the phone here so y'all can screenshot this. Because you guys can use this like immediately. Okay? This is important. You guys can definitely use this. So I'm highlighting right now. Be patient with me a little bit, please. Hold the phone so y'all can screenshot this. And this will be like a little cue card you can look on your phone to study. Okay? This is important for you to know how to reserve your rights, how to protect yourself when you're out in the public. Everyone needs to be sharing this with every melanated black male, whatever. We're not black, but we're melanated. You need to be sharing this with everyone to protect themselves when you're out and about, okay? Because it's getting real out here, y'all, okay? So I'm going to hold that up there and make sure y'all screenshot it. Let me see. So I hope you guys were able to screenshot that. If so, put a 1 in the chat for me or something. Somebody tell me something. Oh, dang. I didn't see all these comments. Peace to the brothers and sisters. Peace. Peace all y'all would. Waking up people. Yes, I got the book. Both of them. Absolutely. Peace to all of you. All our bills are paid in full. Yes, they are. Most definitely. Okay, so let me keep going on, y'all. I hope y'all was able to screenshot that. What is compelled performance of an unrevealed commercial agreement? When you use Federal Reserve notes instead of silver dollars, it is voluntary. No. I'm sorry. Let me reread that question. When you use Federal Reserve notes instead of silver dollars, is it voluntary? No. There is no lawful money, so you have to use Federal Reserve notes. You have to accept the benefit. The government has given you the benefit to discharge your debts. How nice they are, but if you have not reserved your rights um under 1-308, you are compelled to accept the benefit and therefore obligated to obey every statute, ordinance, and regulation of the government at all levels of government, federal, local, and state. If you understand this, you will be able to explain it to the judge when he asks, and he will ask, so be prepared to explain this statement in the court. You will also need to understand UCC 1-103, argument and recourse. Okay, so if you want to understand this fully, go to the law library and photocopy these two sections from the UCC. It is important to get the Anderson version. Some of the libraries will only have the West Publishing version, which is very difficult to understand. In Anderson, it is broken down with decimals into 10 parts, and most importantly, it is written in plain English. Recourse. Recourse appears in UCC at 1-103.6, which says the code is complementary to the common law, which remains in force except where displaced by the code. A statute should be construed in harmony with common law unless there is a clear legislative intent to abrogate the common law, UCC 1-103.6. This is the argument to use in court. The code recognizes the common law. If it did not recognize the common law, the government would have to admit that United States is bankrupt and completely owned by its creditors, but it is not expedient to admit this. The code was not written to I'm sorry. The code was not written to entirely override the common law. Therefore, if you have made a sufficient, timely, and explicit reservation of your rights pursuant to the UCC 1-308, you must insist that the statutes be construed in harmony with the common law. Okay? Let's see. All right. So moving on. It says, if the charge is a traffic ticket, you must demand. If the charge is a traffic ticket, you must demand that the court produce the injured person who has filed a verified complaint. For example, if you were charged with failure to buckle your seatbelt, you must ask the court who was injured as a result of your failure to buckle up. So y'all need to write that down. However, if the judge won't listen to you, you just moves ahead with the case, you will want to read to him the last sentence of UCC 1-103.6, which states that the code cannot be read to preclude a common law action. Tell the judge, Your Honor, I can sue you under the common law for violating my rights under UCC. I have a remedy under the UCC to reserve my rights under the common law. I have exercised my remedy, construe you must construe this statute in harmony with the common law. To be in harmony with the common law, you must bring forth the damaged party. So let's highlight this, and I'm gonna hold this so y'all can study that too, because that's good to know, right? I don't do court, but those that do and have court issues that they're dealing with, this would be something good for them to know, okay? So I'm going to highlight it and let y'all take a picture of it. A screenshot. Okay. All right. So now you guys take a screenshot. Give you 5 more seconds. All right. So moving forward, it says, note, actually, it is better to use a rubber stamp because this demonstrates that you have previously reserved your rights. The simple fact that it takes several days or weeks to order and get a stamp shows that you have reserved your rights prior to signing the document. Anderson, Uniform Commercial Code Lawyers, Cooperative Publishing Company. Okay, if the judge insists on proceeding with the case, act confused and ask this question. Let me see if I understand, Your Honor. Has this court made a legal determination that the sections of 101-308 and 1-103 of the UCC, which is the system of law you are operating under, are not valid law before this court? Now the judge is in a jam. How can the court throw out one part of the code and uphold another? If he answers yes, then you say, I put the court on notice that I am appealing your legal determination. Of course, the higher court will uphold the code on appeal. The judge knows this, so you have boxed him into a corner. Okay, so I'm going to highlight that too for a second. I hope you guys are appreciating this information because we need to know how to stand up for ourselves, right? How to protect ourselves against these people. Okay? So you need to screenshot all of this. important. Very, very important. So these are very key pointer things that you need to study. All right. So with the highlight it part, you guys can get that right there. Let's see, make sure you can get the whole thing. All right. So moving forward, thank you all for the likes. I appreciate you all for sticking around and listening this far. I definitely appreciate you. And if you would like to make a donation, I do accept donations. You can just email me or send it by Zelle to the email address that's in the description. If you're using Cash App, just email me for the Cash App because I don't have a Cash App, but I can utilize my husband's or my children's. So I don't want to put that on the air though, because I'll just give it to you personally if you email me. Okay. So section 24, practical application in traffic court. Just so we can understand how this whole process works, let's look at a court situation such as a traffic violation. Assume you ran a yellow light and a policeman gave you a traffic ticket. The first thing you want to do is delay the action at least 3 weeks. This you can do by being pleasant and cooperative with the officer. Explain to him that you are very busy and ask if he could please set your court appearance for about 3 weeks away. At this point, we need to remember the government's trick. I'm from the government. I'm here to help you. So we want to use this approach with them. Step 2, the next step is to go to the court of the traffic court and say, I believe it would be helpful if I talk to you because I want to save the government some money. This will get his attention. I'm going to appeal this case. As you know, in an appeal, I have to have a transcript, but a traffic court doesn't have a court reporter. It would be a waste of taxpayers' money to run me through this court and then have to give me a trial, de novo, new trial, in a court of record. I need a transcript for appealing and to save the government some money. Maybe you could schedule me to appear in a court of record. You can show the date on the ticket and the clerk will usually agree that there is plenty of time to schedule your trial for a court of record. Now, your first appearance is in a court of record and not in traffic court where there is no record. When you get into the court, there will be a court reporter there who records every word the judge speaks, so the judge is much more careful in a court of record. You will be in a much better situation than in a traffic court. If there is no record, the judge can say whatever he wants. He can call you all sorts of names and tell you that you have no rights and so on, and deny it later. I hope y'all sucking this up. I'm going to let y'all get a snapshot of this page and probably the next page too. For those that don't have this book, get a snapshot. These are your remedies to help yourself. Okay? All right, moving on. It says, 3, when you get into court, the judge will read the charges, driving through a yellow light or whatever, and this is in violation of ordinance XYZ. He will then ask, do you understand the charges against you? You in step 4, it will say, well, Your Honor, there is a question I would like to ask before I can make a plea of innocent or guilty. I think it could be answered if I could put the officer on the stand for a moment and ask him a few short questions. The judge will say, I don't see why not. Let's swear in the officer and have him take the stand. 5, Is this the instrument that you gave me? Handing him the traffic citation. The officer will say, yes, this is a copy of it. The judge has the other part of it. You will say, where did you get my address that you wrote on the citation? The officer will say, I got it from your driver's license. Number 4 above is very important to get into the record, clearly stating that you do not understand the charges. With that in the record, the court cannot move forward to judge the facts. This will be covered later on. Handing the officer your driver's license, is this the document you copied my name and address from? The officer will say, yes, this is where I got it from. While you've got that in your hand, would you read the signature that's on that license? The officer reads the signature while you're there. The officer reads the signature while you're there. You will say, while you're there, would you read into the record what it says under the signature? So the officer will say, it says without prejudice UCC 1-308. So stopping there, guys. You want to, under your signature, you can write this on the current driver's license that you have, or you can go and get another driver's license. And when you sign the signature card, you can do this, right? Write this, without prejudice UCC 1-308, all rights reserved, okay? Next, under your signature. But you can do it on the existing one that you have now. But like the book said, a stamped one would probably be better because you've already reserved your rights ahead of time, right? Okay. So, moving forward, it says, let me see that license. The judge, this is the judge now. The judge says, let me see that license. He looks and turns to the officer. You didn't notice this printing under the signature on the license when you copied his name and address onto the ticket? The officer will say, oh no, I was just getting the address. I didn't look down there. The judge will say, you're not very observant as an officer. Therefore, I'm afraid I cannot accept your testimony in regards to the facts of this case. This case is dismissed. I hope y'all getting this. This is empowering. Very, very, very empowering. Okay? So, in this case, the judge found a convenient way out. He could say that the officer was not observant enough to be a reliable witness. He did not want to admit the real nature of the jurisdiction of his court. Once it was in the record that you had written without prejudice UCC 1-308 on your license, the judge knew that he would have to admit A, that you have reserved your common law rights under the UCC, and B, that you have had done it sufficiently by writing without prejudice UCC 1-308 on your driver's license, or C, that the statute would now have to be read in harmony with the common law, and the common law says that the statute exists, but there is no injured party. D, that since there is no injured party or complaining with witness, the court has no jurisdiction under common law. Okay? So this is good stuff, guys. Let me know if y'all sucking this up like I am, okay? Because this is extremely empowering. If the judge tries to move ahead away and tries the facts of, if the judge tries to move ahead anyway and try the facts of the case, you will want to ask him the following questions. Okay? You want to ask, Your Honor, let me understand this correctly. Has this court made a legal determination that it has legal authority under the jurisdiction that is operating under to ignore 2 sections of the Uniform Commercial Code which have been called to its attention? If he says yes, tell him that you put the court on notice that you will appeal his legal determination, and if that you are Damaged by his actions, you will sue him in common law action under this jurisdiction of the UCC. This will not work. This will work just as well with the Internal Revenue Service. In fact, we can use the UCC with the IRS before we even go to court. Section 25, using the code with the IRS. If the IRS sends you a notice of deficiency, this is called a presentment. In the UCC, a presentment in the UCC is very similar to the common law. First, we must understand just how this works in common law. Suppose I get a man's name from a phone book, someone I have never met, and I send him a bill or an invoice on a nice letterhead which says, for services rendered $10,000, and I send this to him by certified mail. Return receipt requested at the address taken from the phone book. The man has to sign for it before he opens it. So it so I get a green card receipt that he received it. When he opens it, he finds an invoice for $10,000 and the following statement. If you have any questions concerning this bill or the services rendered, you have 30 days to make your questions or objections known. Of course, he has never heard of me, so he just throws the bill away and assumes that I'm confused or crazy. At the end of 30 days, I go to court and get a default judgment against him. He received a bill for $10,000 and was given 30 days to respond. He failed to object to it or ask any questions about it. Now he is defaulted on the bill and I can lawfully collect the $10,000. This is common law. The UCC works on the same principle. The minute you get a notice of deficiency from the IRS, return it immediately with a letter that says, the presentment above is dishonored. Your name has reserved all his rights under the Uniform Commercial Code at UCC 1-308. This should be all that is necessary, and there is nothing more they can do. In fact, I recently helped someone in Maine who received a notice of deficiency. The man sent a letter such as this dishonoring the presentment. The IRS wrote back saying that they could not make a determination at that office, that they were turning it over to collections department. A letter was attached from the collections department which said that they were sorry for the inconvenience that they had caused and that the notice of deficiency had been withdrawn. So you can see that if it's handled properly, these things are easily resolved. I hope you all are paying attention. You gotta pay attention. You're gonna have to pay something. The least you can do is pay attention, right? And get this information and help yourself. That way you don't have to pay no Federal Reserve notes and keep punching into people's clocks, right? For unnecessary reasons. All right. So moving on. 26, Section 26, impeding bankruptcy. On my way here, I had a chance to visit the government of blank. He is very concerned that if he runs for office this November, that there won't be a state at the end of 4 years. Excuse me. At the end of 4 years. He believes that the international bankers might foreclose on the nation and officially admit that they own the whole world. They could round up everybody in the state capitol building, put them in an internment camp, and hold them indefinitely. They may give them a trial, or they may not. They may do whatever they want. As I explained earlier, it is not been expedient to foreclose on the nation until they could get everything ready. This is where the Federal Emergency Management Agency comes in. It has been put in place without anyone really noticing it. And the Federal Emergency Management Agency is FEMA, you all. Section 27. FEMA, or the Federal Emergency Management Agency, has been designed for when America is officially declared bankruptcy, which would be a national emergency. In a national emergency, all constitutional rights and all law that previously existed would be suspended. FEMA has created large concentration camps where they would put anyone who might cause trouble for the orderly plan and process of this new regime to take over the nation. Even a governor could be thrown into one of these internment camps and kept there indefinitely. This is all in place now, and they are just wanting to declare a national emergency, or just waiting to declare a national emergency. Then even the state governments could be dissolved. Anybody who might oppose the new regime could be imprisoned until a new set of laws could be written and a new government set up. The government now knows all this and has very the governor knows all this and he is very concerned. He doesn't want to be in office when all this happens. Harold Freeman, visited him with him and told him that there are certain actions we should have right now, or we should take right now. I think that we should consider the fact that according to the UCC, each state is an accommodation party to the national debt. To understand this, we must realize that there are two separate entities known as the United States. Section 28, the Rothschild influence. When America was founded, the Rothschilds were very unhappy because it was founded on the Christian common law. The common law is based on substance, and this substance is mentioned in the Constitution as silver and gold. America is a constitutional republic, which is a union of the states under the Constitution. When Congress was working for the republic, the only thing Congress could borrow or issue was silver and gold, and the Rothschild banks did not lend silver or gold. Naturally, they did not like this new government. The Rothschilds had a deal with the King of England. The king would borrow paper and agree to repay in gold. But these United States, with their constitution, were an obstacle to the Rothschilds, and it was much to their knowledge to get the colonies back under the king. So the Rothschilds financed the War of 1812 to bring America back under the British crown. It didn't work as planned, so they had to find another way. Section 29. The flaw in the Constitution, the two nations in one. Around the time of America's Civil War, they discovered a flaw in the Constitution. The flaw was Article 1, Section 3, Clause 17. Remember, there are two nations called the United States. Which is a nation? See if you agree with this definition. Or what is a nation? See if you agree with this definition. Whenever there is a governing body having a prescribed territory containing a body of people, this is an easy to understand restatement of the definition presented in Black's Law Dictionary. Is this a nation? Yes. We have a governing body in the Republic, a three-branch government, legislative, executive, and judicial branches under a constitution. We have a prescribed territory containing a body of people and a constitutional republic. But Article 1, Section 8, Clause 17 gave Congress the legislative branch of the three-branch government, exclusive rule over a different territory containing a body of people, District of Columbia. Here we have a nation within a nation, a legislative democracy within a constitutional republic. When Congress was part of a constitutional republic, it was obligated to provide a medium of exchange for the people. Its duties was to coin silver and gold. Anyone who had a piece of silver or gold could bring it in and have it freely minted into silver or gold coin. This was the medium of exchange for the republic. But in the legislative democracy over Washington, D.C., Congress is not limited by the Constitution. Congress has exclusive rule over the District of Columbia and its people. The legislators in the District of Columbia can make the laws by a majority vote because the District of Columbia is a democracy wherein their administrative agents enforce their own laws and the administrative courts in the government try their own laws. Here we have the legislator making the law, enforcing the law, and trying the law. And within the one branch of government, this is a one branch government within a three branch government. Under the three branch government, Congress passes laws which must be in harmony with the Constitution. The executive enforces these laws passed by Congress, and the judiciary tries these laws passed by Congress pursuant to the Constitution. The three branch constitutional republic and the one branch legislative democracy, both called the United States. One is the continental United States, and the other is the federal United States or the federal zone. Section 30. Are you a United States citizen? If you say that you are a United States citizen, which United States are you referring to? Anyone who lives in the District of Columbia is a citizen of the United States. The remaining population of the Union of the 50 states are national citizens of the nation. We are domiciled in the various sovereign states and protected by the constitutions of those states from any direct rule of Congress over us. In the democracy, anyone who lives in the states known as Washington, D.C., Guam, Puerto Rico, or any of the other federally held territories is a citizen of the United States or D.C. We must be careful with our choice of words. We are not citizens of the United States. We are not subject to Congress. Congress has exclusive rule over a given territory, and we are not part of that territory. Where did Congress get the authority to write the Internal Revenue Code? It is found in Article 1, Section 8, Clause 17 of the Constitution. To pass that law they only needed a majority vote. There is no other way that they can pass laws directly affecting individuals. Excuse me. Okay. Title 26, the Internal Revenue Code, was passed as law for a different nation. Remember our definition of nation. Title 26 is not consistent with the Bill of Rights. If you try to fight the IRS, you have no rights. The IRS code does not give you your constitutional rights. It simply says you failed to file an income tax form. You failed to perform in some specific manner. Remember, under the common law, you are free to do whatever you want to do as long as you do not infringe upon the life, liberty, or property of anybody else. If you do not want to perform, you do not have to. The only way you can be compelled to perform under the Constitution of the continental United States is if you have voluntarily entered into a contract. But if you are not under a contract, you cannot be compelled to perform. You cannot be compelled to file an income tax form. When Congress works for the Republic, every law it passes must be in harmony with the Constitution and the Bill of Rights. But when Congress works for the legislative democracy, any law it passes becomes the law only over federal territory. If you are charged with willful failure to file a 1040 income tax form, That form is of and for a different nation, which you're not a resident alien of that nation. If a foreign corporation, it is a foreign corporation to you. It is not the Republic of the Continental United States coming after you. It is a foreign nation, the legislative democracy of a foreign nation coming after you. If you get a notice of deficiency from the IRS, it is a presentment from the federal United States. So you can use the UCC to dishonor it, and you can tell the IRS that you are among the national citizenry of the continental United States, that you are not a non resident alien to the federal United States. You never lived in the federal zone, a federal territory, and you never had any income from the federal United States. Furthermore, you cannot be required to file or pay taxes under the compelled benefit of using the Federal Reserve notes because you have reserved your rights under the common law through UCC 1 308. I hope you guys got all of that. And if not, you can definitely go and rewind it and pause it and be able to take those notes to be able to use this information to assist you yourselves with whatever situation that you're facing, okay? Now, I don't think I'm going to get through this entire book today, but I will come back and do a part 2. So it looks like it's about 66 pages long. So what I'm going to do is read maybe the next 3 pages up to page 33, and then I'll end for the day and make this a 2-hour video. And then we'll come back tomorrow for the remainder of the book. All right. Again, I hope you guys appreciate the information. Great day, Mr. Curtis. Thank you for joining us. And thank you all for watching. So I'm going to go ahead and continue on reading from section 31, page 30, on to the next couple of pages, and then we'll end for the day. Please share this video with everyone that you know, guys. This information needs to get out. We need to start educating ourselves, okay? So we can start freeing ourselves. All right. Section 31, original intent of the founders. The founding fathers who would never would never have created a government that was going to boss them around. There were 13 sovereign states. There were nations with which they joined together in union for protection from foreign enemies. They provided a means by which the union of sovereign states could fend off foreign and domestic enemies, but they never gave the Congress of the Federal United States direct rule over any citizen of any union state. They were not going to be ordered around by the government that they set up. Okay, federal region. Section 32, the federal zone. The Supreme Court has declared that Congress can rule what Congress creates. Congress did not create the states, but Congress did create federal regions. So Congress can rule the federal regions, but Congress cannot rule the federal states. How have we been tricked into federal regions? The zip code trick. Remember how the government always comes to use and say, I think that's supposed to say us, comes to us and say, I'm from the government and I've come to help you out. The government went to the various states and said, we don't want you to go to all that trouble of writing 3 or 4 letters to abbreviate the name of your state. I'm sorry, let me see. We don't want you to go to all that trouble of writing 3 or 4 letters to abbreviate the name of a state, such as Arizona for ARIZ for Arizona, just write AZ instead of ARIZ, or you can write WY for Wyoming instead of WYO. So all the states of the Union have been given two-letter abbreviations. Even a state such as Rhode Island has a new abbreviation, which is RI instead of R.I. They just left off the period. When you use a two-letter state abbreviation, you are compelled to use the zip code, the zone improvement code. Because there are many states which start with the same letter. For example, M or ME is Maine and Michigan is MI. MS is Mississippi. With MA, MO, MN, MS, etc., the some sloppy writing, and you could not tell one from the other. So we use the zip code in order to tell them apart. But if you write MICH or MINN or MISS, there would be no problem telling them apart. There's no harm in using the zip code if you lawfully identify your state. I found out that no state legislator has met to lawfully change the abbreviation of their state from its old abbreviation to the new. Therefore, if you do not use the lawful abbreviation for your state but use the new legal shorter abbreviation, you have to use the zip code. So what we've discovered, guys, is that just to pause on the reading and about the zip code, even if you write the state out and all in full, and you use the zip code, which you don't have to use it, and you can always put zip exempt. But if you're going to use the zip code, just put it in brackets. Put the zip code in brackets. But you want to separate yourself from the federal zones by always writing out the state in its full name and then putting the zip codes in brackets. Never use the abbreviations, because that keeps you in their federal zone or territory, okay? So you have to remember that to separate yourself, okay? So Section 34, accommodation party. Let's look at how the states have become the accommodation party to the national debt. Many people who I have talked to, including the governor, are very concerned about this and and know that it could happen very soon. If America is declared a bankrupt nation, it will be a national emergency. FEMA will take over, and anyone who opposes the creditors' new government can be sent to a detention camp in Alaska. We will have no rights whatsoever. Y'all hearing this, right? This is the plan that they have for the people, okay? So we have to be knowledgeable about this so we can prepare and do what we need to do to keep ourselves from running into this type of trouble, okay? They have already set up prison camps with work camps nearby so the people can be used for slave labor. It could be the governors, legislators, and other leaders who would be hauled away to Alaska, while the people now disenfranchised from power would likely be chosen to run the new government. This could all happen very soon, as the national debt is so large as to be unpayable. Even the interest on the debt is virtually unpayable. As I explained, the national debt, more than $3 trillion, now $17 trillion, and that was when this book was written. Now it's like 27 trillion, probably 28 or 29 trillion. If you look up on the usdebtclock.org, you'll see what the current debt is. Last I looked, it was like 27 trillion. Okay, and they're constantly printing up more money and more money and more fraudulent paper money. Okay. So it says, it is not owed by the continental United States. It is owed by the federal United States that was given the authority to back bank credit. When Congress worked for the continental United States, it could only borrow silver and gold. Therefore, the national debt was borrowed by the federal United States. The federal United States had to trap the United States into assuming the debt obligation of the federal debt. The UCC, we find the term accommodation party. How did the states become the accommodation party to the federal debt? The federal government forced the states to deal in Federal Reserve notes, which means that everything that the states do and have done is colorable. Under the colorable jurisdiction of the UCC, all the states are accommodation parties to the federal debt. The concern now is to find out how we can get out of this situation. I told the governor that in the common law and the common merchants, the international law merchant, there's a term called no interest contracts. A no interest contract is unenforceable and void. What is a no interest contract? 35. No interest contract. If you were to insure a house that did not belong to me, that would be a no interest contract. I would just want to have I would just want the house to be burned down. I would pay a small premium, perhaps a few $100s, and insure it for 80,000 against fire. Then I would be waiting for the house to burn down so I could trade my small premium for $80,000. I would have no interest in living in or owning the house. Under the common law, this is called no interest contract, which is unenforceable in any court and therefore void. Unconscionable contracts. No interest contracts are called unconscionable contracts. The section in the in the Anderson Code of Unconscionable Contracts covers more than 40 pages. The federal United States has made each state an accommodation party to the federal debt, which could be proven to be an unconscionable contract. We should get some litigation into the courts before the government declares a national emergency, claiming that this state has no lawful responsibility for the national debt of the federal United States because it claims because it became an accommodation party to this debt through an unconscionable no interest contract. If we have this litigation before the courts under international law, when the nation is declared bankruptcy, the creditors would have to set this matter before first, and it would delay them. They would want the new government to appear legitimate so that it could not just move right in and take over the state because it would be an international court this is very important at this time. Okay, so I'm going to read these last few pages because it talks about questions and reviews. And what we'll do is tomorrow we'll pick up on section 39. So it says section 37, questions and reviews. Note, these are some of the questions asked after the main lecture. Some are restatements of material presented earlier, but they contain valuable information worth repeating. Courtroom technique, section 38. How did you box in the judge? A. This is easy to do if you don't know too much. I didn't know too much, but I boxed them in. Just remember that in a criminal action, you must understand the law or it is a reversible error for the court to try you. If you don't understand the law, then they can't try you and have to dismiss the case. So if you don't understand the law, they can't try you, okay? So basically you tell them you don't understand. In any traffic case or tax case, or you are called into court and the judge reads the law and then asks, do you understand the charges? As a defendant, you say, no, Your Honor, I do not. You don't understand. The judge will say, well, what is so difficult about the charge? Either you drove the wrong way, one way, or on a one-way street, or you did not. You can only go one way on the street, and if you go the other way, it's a $50 fine. What's so difficult that you don't understand? As a defendant, you're going to say, well, Your Honor, it's not the letter of the law, but rather the nature of the law that I don't understand. The Sixth Amendment of the Constitution gives me the right to ask the court to explain the nature and cause of action against me, and upon my request, the court has the duty to answer. I have a question about the nature and cause of this action. The judge will say, well, what is that? What what do you want to know? The defendant will say, well, Your Honor, is this a criminal or is this a civil or criminal action? The judge will say it is criminal. If it were a civil action, there would be no fine, so it has to be criminal. The defendant will say, thank you, Your Honor, for telling me that. Then the record will show that this action against, which will at the time you will say your all capital letter name, is a criminal action. Is that right? The judge will say yes. The defendant will say, I would like to answer another question about this criminal action. There are two criminal jurisdictions mentioned in the Constitution. One is under common law and the other deals with international maritime contracts under Admiralty jurisdiction. Equity is civil, and you said that this is a criminal action, so it seems it would have to be under either common or maritime law. But what puzzles me, Your Honor, is that there is no corpus delicti, or there's no corpus delicti here to give this jurisdiction over my person and property under the common law. Therefore, it doesn't appear that this court is moving under common law. The judge will say, no, this court is not under common law. The defendant will say, well, thank you, Your Honor, but now you make the charge against me even more difficult to understand. The only other criminal jurisdiction would apply only one if there were international maritime contract involved, or two, I was a party to it, and three, it had been breached, and four, the court was operating in an Admiralty jurisdiction. I don't believe I have ever been under any Admiralty maritime contract, so I would deny that one exists. I would have to demand that such a contract, if one does, be placed into evidence so that I may contest it. But surely this court is not operating in an Admiralty jurisdiction. You just put the words in the judge's mouth. The judge will say, no, I can assure you we're not operating in an Admiralty jurisdiction. We're not out in the ocean somewhere. We're right here in the middle of the state. No, this is not an Admiralty jurisdiction. Defendant will say, thank you, Your Honor. But now I am more puzzled than ever. If this charge is not under the common law nor under Admiralty, and those are the two criminal jurisdictions mentioned in the Constitution, what kind of jurisdiction could this court be operating under? The judge will say it's statutory jurisdiction. The defendant will say, "Oh, thank you, Your Honor. I'm glad you told me that, but I have never heard of that jurisdiction. So if I have to defend myself under that jurisdiction, I would need to have the rules of criminal procedures for statutory jurisdiction. Can you tell me where I might find such rules?" There are no rules for statutory jurisdiction, so the judge will get very angry at this point and say, if you want answers to questions like that, get a licensed attorney. I'm not allowed to practice law from the bench. The defendant will say, oh, Your Honor, I don't think anyone would accuse you of practicing law from the bench if you just answered a few questions to explain to me the nature and cause of this action so that I can defend myself. The judge will say, I told you before I am not going to answer any more questions. Do you understand that? If you ask any more questions in regards to this, I'm going to find you in contempt of court. Now if you can't afford a licensed attorney, the court will appoint one for you. But if you want those questions answered, you must get a licensed attorney. You as the defender will say, thank you, Your Honor, but let me just see if I got this straight. Has the court made a legal determination that it has authority to conduct a criminal action against me, the accused, under a secret jurisdiction, the rules of which are known only to the court and licensed attorneys, thereby deny me that right to defend myself in my own person? He has no answer for that. The judge will probably postpone the case and eventually just let it go. In this way, you can be wise as a serpent and harmless as a dove, but you must not go into the court with a chip on your shoulder and as a wolf in black sheep country. Remember Jesus' words, I send you forth as sheep in the midst of wolves. Be ye therefore wise as serpents and harmless as sheep. Do not attack wolves directly. Just be an innocent lamb who just can't understand the charge. And remember, they can't try you criminally if you don't understand the charge. That would automatically be a reversible error on appeal. So that completes this today's reading, you all. Welcome, Farah Ashford. I'm reading The UCC Connection, How to Free Yourself from Legal Tyranny. So we just read the first 37 pages of the book, first 36 pages. There's about 30 something more to go, which I'll complete tomorrow. So I will definitely be back tomorrow to finish this book for you all. I hope you all appreciated the reading today. If you'd like to make a donation for my reading and my time, you may definitely do so through Zelle at the email address that's in the description of the video of this video. Or if you want to send through Cash App, you will definitely have to email me at that same email address to get the Cash App information, because I don't want to make it public. Okay, with that being said, I appreciate you all. Make sure you all join the Telegram chat. Reach out to me in there. If you need to schedule personal consultations, just reach out to me in the Telegram chat. Telegram is where it's at, you guys. That's where all of the magic is happening. All of the unity is happening with people, and we're coming together and unifying and learning this information together and putting our heads together and figuring out ways to get remedy for ourselves, even when they come and try to block us. Okay, we definitely are getting remedy. So with that being said, it is your girl Shay Marie. I hope you guys appreciate this again. I appreciate you all for taking the time to stop by and show me some love and your appreciation. Thank you for the thumbs up and all. And I look forward to getting to know each and every one of you and helping you all in your journey towards freedom. With that being said, peace and love, and you guys enjoy your day.